Or let me just use the Jeopardy rule. As you know, on the popular television program Jeopardy, everything has to be in the form of a question. So we will take as many questions as we have time for, and in order to give as many as we can the opportunity to ask questions, please make your questions brief and to the point, and make sure it ends with a question mark rather than a statement. Let me open, John, if I may, by reading an excerpt from the David Margolis memorandum dated January 5th, 2010.
Is this a question? Yeah, what is this?
This is a question.
Is this a question? Yeah,
Yes, this is a question.
Form.
Margolis is a whitewash. Please don't bother. We have the report. We have the OPR report. We don't need Margolis. Ask the question.
Well, the rest of us who aren't as smart as you are would like to hear.
What he says towards the end of this report is, while I have declined to adopt the findings of misconduct of the Office of Professional Conduct, I fear that John Yoo's loyalty to his own ideology and convictions clouded his views of his obligations to his client and led him to author opinions that reflected his own extreme, albeit sincerely held, views of executive power while speaking for an institutional client. It goes on to say these memoranda suggest that he failed to appreciate the enormous responsibilities that comes with the authority to issue institutional decisions that carry the authoritative weight of the Department of Justice. In light of the questions that have been raised about the impartiality and even the accuracy of your legal memoranda, what does this do to the opinions that you expressed early in the war on terror?
Well, first, let me say that, Mr. Margolis' view is that he rejected finding any kind of professional misconduct, but he concluded that I and the other lawyers in the office at the time exercised poor judgment or bad judgment. And I'll say, first, I respect Mr. Margolis' opinion. I mean, he's a civil servant been in the Justice Department for, I think, 40 years, since the Nixon administration. And I never worked with him, but he's sort of famous within the department as being the sort of ultimate professional civil servant. He has his view about the fact that he thinks we exercise bad judgment and that we're driven by ideology. I think lawyers, especially dealing with questions like this, are going to differ and think that people on the other side exercise poor judgment. I mean, if the Supreme Court, if the worst they could call each other in the majority and dissenting opinions was that they had poor judgment, the decisions would be actually really short. Because that's the reason we have majority and dissenting opinions, even at the Supreme Court. In the elite cases, hardest cases, 5 justices of the Supreme Court can disagree, and they will accuse each other against 4 justices who disagree. And they'll accuse each other of much worse things than poor judgment. So let me also say, these questions that we faced after 9/11, I do disagree with his idea that this was driven by ideology. I mean, Frank, these are not questions that any of us ever wished or hoped that we'd ever have to confront in the government. These are the questions that were thrust on us by the 9/11 attacks.
They were in place before that, sir.
Then you really are paranoid.
No, sir, they were.
These are not questions that we ever.
We played an attack on Iraq.
These are not questions that any government servant ever hopes to or ever wants to address, and I wish we never had to, frankly. And I didn't go into the government in order to do so. However, I do think that what happened caused our government to have to consider these kinds of policies because of the unconventional nature of the 9/11 attacks and the unconventional nature of the enemy we fight. I mean, because we are fighting an enemy that is not a nation, that does not wear uniforms, does not organize in regular units, that conducts itself by violating all the laws of war, by deliberately targeting civilians, disguising themselves as civilians and using airliners to carry out attacks on the United States. Unfortunately, the conventional ways we fight most of our enemies in the past aren't going to work. We're not going to beat Al-Qaeda by fielding larger armored divisions and driving them across Europe and capturing an enemy capital. Unfortunately, because of the nature of the conflict, the way that the United States is going to prevail is by gaining intelligence and information about the enemy's plans before they happen and trying to stop them. I think that's unfortunate, and I don't think the Obama administration disagrees with the Bush administration about that.
Next
And
question.
the problem is that we have to figure out what to do. And that's why we had to confront those questions. Second thing I'll say in response to this is that I think it is a fallacy to think that the law gave obvious and clear answers to these questions. Questions about how far the United States can go in interrogation is not clearly set out by Congress. And so we in the Justice Department had to answer questions put to us by the CIA about how far can we go in interrogation so as not to violate the Congress's ban on torture. And that's the question we set out to answer. We knew at the time, and constantly reaffirmed like days like this, that those answers were going to be controversial. No matter where we drew the line, people were going to be upset and were going to disagree with us. And we understood that as well. But thank you very much.